Hi, I'm Blake Lively, and I'm going to be taking the BuzzFeed quiz, which iconic Blake Lively character.
HI besties, welcome back. Tio Coravanta. The legal battle swirling around Isabela Ferrer, Blake Lively, Ryan Reynolds, Wayfair and Justin Baldoni has taken on an increasingly complicated and dramatic turn. Recently, Isabela Ferrer, a young actress who has been drawn into the litigation almost against her will, filed an opposition in court that raises a host of unusual arguments. At the center of her filing is an effort to oppose alternative means of service and, even more strikingly, a demand for sanctions against Baldoni. Yet curiously, the motion never explicitly requests that the subpoena issued against her be quashed. This omission sets the tone for what has become a confusing and somewhat hostile 26-page motion, one that is infused with fiery rhetoric and language aimed squarely at Baldoni while, interestingly, leaving Wayfair largely untouched despite the fact that the subpoena originated from Wayfair's legal team, not Baldoni himself. From the outset, what strikes many legal observers as odd is the manner in which Ferrer's filing repeatedly singles out Baldoni by name. Over and over again his name appears almost strategically while the larger corporate entity of Wayfair, which is actually the party responsible for the subpoena, is barely mentioned in comparison. This emphasis suggests something more personal than professional, a calculated attempt to conflate Baldoni with the entirety of Wayfair's legal efforts. Even more perplexing is the fact that Ferrer's language mirrors accusations that had previously been leveled at Blake Lively and Ryan Reynolds by critics of their own legal maneuvers against content creators. In both tone and substance, Ferrer's accusations feel like an echo chamber of grievances that have been circulating in related cases, further raising the suspicion that her motion was not written in isolation but was perhaps influenced or even coordinated with Lively's legal strategy. The heart of Ferrer's motion lies in its accusations of improper behavior by Baldoni. The document accuses him of attempting what she calls a quid pro quo, a misphrasing of the Latin quid pro quo, essentially alleging that Baldoni tried to leverage compliance in one area in exchange for concessions in another. This is a serious accusation as quid pro quo implies a form of bribery or coercion. To understand the gravity of this claim, one must recall that only weeks earlier, Ryan Reynolds had himself been accused of entering into a quid pro quo arrangement with law enforcement in Vancouver in an attempt to secure an arrest. Now, suddenly, in Ferrer's filing, similar language and accusations are leveled against Baldoni. The timing and choice of words are unlikely to be coincidental, reinforcing the perception that Ferrer and Lively's teams may be working in coordination behind the scenes. Adding further intrigue is the fact that Ferrer has previously cooperated with Lively. In fact, she complied with Lively's subpoena by handing over communications that were requested, even while resisting Wayfair's efforts. At the same time, she has been engaged in an ongoing dispute with Wayfair over indemnification. Indemnification, in the employment and entertainment industry context, is a standard legal protection wherein the employer agrees to cover the costs of legal fees and liabilities that arise as a byproduct of the employee's work. In practice, this means that if an actor or employee is subpoenaed or sued because of their work on a project, the employer steps in to provide legal coverage and financial protection. However, Ferrer has resisted Wayfair's attempts to indemnify her. Instead, she has chosen to hire and rely on her own attorney, creating a natural tension between herself and her employer. Wayfair, for its part, has insisted that indemnification means not only paying for Ferrer's legal representation but also managing the process, handling document production and ensuring compliance with subpoenas on her behalf. Ferrer, however, views this as an infringement on her autonomy, interpreting it as an effort to control her and limit her independence. Her legal counsel has gone further, taking a particularly hostile stance against Baldoni. The filing is full of hyperbolic and inflammatory language, describing Baldoni's actions as part of a campaign of harassment against Ferrer. The word harassment is used liberally, as though being subpoenaed to provide testimony and documents in a legal case were tantamount to bullying or intimidation. This is, of course, unusual. Subpoenas are not personal attacks. They are legal instruments authorized by a court to compel the production of evidence or testimony relevant to a case. The accusation that a subpoena amounts to harassment stretches the boundaries of legal interpretation and raises eyebrows among legal professionals. What makes this even more puzzling is that the subpoena in question did not even originate from Baldoni directly but rather from Wayfair's attorneys. Baldoni himself is only one of several figures associated with Wayfair, which is primarily owned by Steve Sarowitz and led by CEO Jamie Heath. Baldoni is not the sole actor here, yet Ferrer's filing fixates on him almost obsessively. The inconsistency becomes more glaring when one compares Ferrer's treatment of Lively and Baldoni. When Lively issued a subpoena to Ferrer, demanding documents that had been provided in response to any other subpoenas in the litigation, Ferrer complied. She did not call Lively's subpoena harassment, intimidation, or an act of control. Yet when Baldoni's team issued an almost identical subpoena, asking for the same category of documents, Ferrer denounced it as harassment. The contradiction is difficult to reconcile and suggests selective outrage. It seems that Ferrer is more than willing to comply with Lively while resisting Baldoni, a choice that betrays underlying loyalties and alliances. Moreover, her legal team has framed Baldoni's subpoena as part of a broader attempt to paint her as non-compliant, a strategy they claim is intended to tarnish her reputation. But again, subpoenas are neutral legal mechanisms, not tools for personal vendettas, and framing them as harassment undermines the seriousness of her claims. One of the most peculiar aspects of Ferrer's motion is the claim that Baldoni's team cited a phony legal case, what her attorneys describe as an AI hallucination, to support a frivolous legal position. If true, this would be highly unusual and problematic, as courts expect attorneys to cite legitimate, verifiable precedents. Yet even here the filing's language veers into the dramatic, accusing Baldoni of manipulating the press and attempting to destroy Ferrer's budding career. The motion describes Baldoni's actions as part of a campaign to create havoc in Ferrer's life, to intimidate her and to publish her personal information in violation of court rules. But again, when one compares this with Lively's actions, the disparity is striking. Lively subpoenaed Ferrer in a similar manner, yet Ferrer's attorneys did not accuse Lively of harassment. The double standard could weaken Ferrer's credibility in the eyes of the court. Underlying all of this is the issue of indemnification. Ferrer has demanded indemnity from It Ends With Us Movie LLC, as required by her contract, which covers multiple theatrical motion pictures. This demand is legally sound. Actors typically rely on their employers to cover legal expenses arising from work-related disputes. However, Ferrer has resisted allowing Wayfair to manage the process, preferring to hire her own attorney. This independence has created friction, as Wayfair has sought to ensure that it controls the process to some degree, consistent with indemnification. Ferrer and her counsel have interpreted this as an attempt at control, framing it as a quid pro quo arrangement, while Wayfair insists it is standard legal practice. The conflict has led to a breakdown in communication, with Ferrer's attorneys refusing to accept service of subpoenas and accusing Baldoni of inappropriate conduct. What complicates matters further is that the communications between attorneys, which have been included in the record, do not appear to support Ferrer's claims of harassment. The emails exchanged between Mitra, an attorney for Wayfair, and Ferrer's attorneys are professional in tone and focused on resolving indemnity issues. Mitra asked whether Ferrer's attorney would accept service of the subpoena, a routine question. At no point does the communication suggest harassment or coercion. And yet Ferrer's attorneys have characterized this as evidence of quid pro quo, a claim that seems exaggerated at best. The reality appears to be that Ferrer is resisting the subpoena altogether, not merely the manner in which it was served. It is also important to note that the presiding judge in this case has dealt with similar issues before. In other instances, when multiple parties subpoenaed the same witnesses, such as Stephanie Jones and Blake Lively both subpoenaing individuals like Chloe and Case, the judge required the witnesses to comply with both subpoenas, even if it meant producing overlapping documents. The rationale was simple. While requests may overlap, each party has the right to obtain evidence independently, and witnesses cannot pick and choose which subpoenas to honor. Given this precedent, it is unlikely that the court will view Ferrer's resistance as valid. More likely, the judge will require her to comply with Baldoni's subpoena, just as she complied with Lively's. At the core of this conflict lies a deeper issue: Ferrer's perception of Baldoni. Her filing portrays him as manipulative, intimidating, and predatory, while her actions suggest a willingness to cooperate with Lively. Whether this perception is the result of personal influence from Lively or simply Ferrer's own interpretation, it has clearly colored her legal response. The fact that her attorney describes the subpoena as part of a campaign of harassment underscores how emotionally charged the situation has become. Yet the legal reality is that subpoenas are not harassment. They are court orders and compliance is mandatory unless a motion to quash is granted. Filing a motion that demands sanctions but does not even request the subpoena be quashed reflects this tension. Ferrer is protesting the process without taking the one step that would legally resolve her grievance. Ultimately, Ferrer's filing feels less like a measured legal document and more like an emotional reaction to being drawn into litigation she does not want to be part of. At just 26 pages, it is filled with accusations, hyperbole, and hostility but lacking in substantive legal arguments that would justify quashing the subpoena. Her focus on Baldoni to the exclusion of Wayfair raises questions about the true motives behind the motion and the extent of her alignment with Lively. In the end, the court is unlikely to be swayed by inflammatory language or accusations of harassment. The judge will likely focus on the legal question at hand, whether Ferrer must comply with the subpoena. Given precedent and the evidence, it seems almost certain that the answer will be yes. In the labyrinth of Hollywood's glittering facade where fame, power, and influence often eclipse truth and morality, the saga of Blake Lively and Ryan Reynolds' courtroom theatrics has become one of the most damning illustrations of how celebrity privilege manipulates the justice system, warps public perception, and reshapes narratives in ways that leave the unsuspecting audience hypnotized by lies wrapped in designer gowns and charismatic interviews. Because beneath the surface of red carpet, smiles and carefully curated Instagram posts lies a festering narrative of manipulation, courtroom deceit, and behind-the-scenes maneuvering that paints a much darker portrait of two celebrities who weaponized their influence not only to protect themselves but to crush those who dared to stand in their way. And when one starts unpacking the layers of this legal scandal, it becomes disturbingly clear that what was sold to the world as an airtight courtroom victory was in reality a choreographed PR spectacle designed to cover up damning truths, silence opposition, and distort the record so completely that ordinary onlookers were left applauding the very people orchestrating the lies. Because the court filings, the witness testimonies, and the legal maneuvers reveal that far from being innocent victims of gossip or malicious litigation, Blake Lively and Ryan Reynolds actively cultivated a narrative of victimhood while pulling strings behind closed doors to engineer a verdict that favored their image above justice itself. And the deeper one digs into the subpoenas, the cross-examinations, and the manipulative tactics, the more one realizes this wasn't merely about winning a case. It was about rewriting history in real time, weaponizing public sympathy, and ensuring their empire of brand deals, film projects, and Hollywood influence remained untouchable even as evidence of deception piled up in black and white before the court. Because nothing exposes the fragility of truth in Hollywood more than watching jurors, reporters, and fans being spoon-fed a story carefully massaged by PR experts while the actual evidence told a completely different tale. And in this case, the tale begins with how selective leaks were used to smear opposition while concealing contradictions in Blake's own testimony. Contradictions so glaring that in any ordinary lawsuit they would have destroyed credibility. Yet here they were brushed aside, minimized, or spun as misunderstandings. While her team leaned heavily on her image as a beloved actress and doting mother to shield her from deeper scrutiny, and Ryan Reynolds, the ever-charming trickster of Hollywood, played his part to perfection, delivering quips, performing indignation, and amplifying the illusion that his family was under siege by malicious forces. But what he didn't show was how meticulously orchestrated their every legal move was, how attorneys like Brian Friedman pointed out with biting precision that their narrative kept collapsing under the weight of hard facts, and how despite this collapse, a combination of media manipulation, courtroom theatrics, and sheer star power allowed them to stagger through without accountability. Because once you trace the timeline, you see that the moment evidence threatened their carefully built narrative, counterleaks appeared, the narrative shifted, and suddenly the court of public opinion was flooded with sympathetic headlines, as if on cue, distracting everyone from the discrepancies that could have unraveled their case entirely. And nothing illustrates this more than the way subpoenas revealed Blake's editorial involvement in footage she swore she had nothing to do with, a revelation that should have been a smoking gun, proof of dishonesty. Yet somehow even this was spun into an excuse about being misunderstood or taken out of context, showing how skillfully her team could twist direct contradictions into palatable sound bites. While Justin Baldoni, once framed as a dangerous opportunist, emerged through testimony and filings as someone systematically misrepresented and wronged. And yet by the time this truth began surfacing, the damage had already been done, because Blake and Ryan's PR juggernaut had already painted him as a villain, a manipulator, a man bent on exploiting their family. And so when cracks in that narrative began to show, the public was too fatigued, too confused, and too distracted by sensational headlines to notice the inversion of truth, and herein lies the real scandal. That in modern Hollywood the combination of wealth, fame, and access to elite attorneys and spin doctors means you don't necessarily need to win with facts. You simply need to win the optics battle, because once the public buys into your image, the courtroom follows, jurors bend, judges hesitate, and suddenly lies don't look like lies anymore, they look like misunderstandings, different interpretations, or harmless mistakes. And so as the dust settled, what should have been a reckoning for Blake Lively and Ryan Reynolds was instead packaged as a vindication, their so-called victory celebrated across tabloids while the voices pointing out contradictions were sidelined, dismissed, or drowned out by the roar of celebrity worship. And yet when we look closer, at the legal language, at the cross-examination notes, at the moments in court where Friedman directly exposed the duplicity, we find that the story of this trial is not one of vindication but of evasion, not of justice served but of justice distorted, because Blake's demeanor cracked under pressure, her answers faltered when confronted with evidence of editing, and her credibility teetered on the edge of collapse. And still the machinery of celebrity justice pulled her through, shielding her from consequences that any ordinary person would have faced, proving once again that Hollywood is less about truth than it is about performance. That the courtroom itself becomes a stage when enough money and fame are involved, and that the public, conditioned to consume narratives rather than facts, ends up clapping for the very illusions that cheat them of reality, because ultimately this scandal is not about two actors lying in court, it's about how those lies were elevated into a spectacle, disguised as heroism, and sold back to us as entertainment, leaving us to cheer while the truth was buried in plain sight. And if that doesn't expose the rotten intersection of fame and justice, nothing ever will. Thanks for watching. Subscribe my channel,